one priority.
That is demonstrably false, because this is written instruction. Making arrests and initiating prosecution is not the goal. That's not an instruction to enforce the law. That is exactly the opposite. It is 180 degrees. It is instructing them. It is not the goal to arrest anybody, despite the fact that the criminal statute said they shall.
A criminal statute, clear language, 0 prosecutions. What happens when the people responsible for enforcing the law decide, quietly, deliberately, that this particular law doesn't apply? Watch carefully.
Thank you, Mr. Chairman. Ms. Monaco, welcome.
Thank you.
You have a very important job. You're the number 2 person in the Department of Justice. Every U.S. attorney reports to you. The U.S. Marshals report to you. You are responsible for day-to-day operations of the Department of Justice, and in particular, the criminal justice aspects of the Department of Justice. Is all of that correct?
That's correct.
It is unfortunate, Ms. Monaco, that as you look back over the last 2.5 years, this Department of Justice, I believe, has been the most partisan Department of Justice we've ever seen. And that is directly contrary to the mission of DOJ. DOJ is meant to be nonpartisan. It is meant to enforce the law, regardless of party. I had hopes that Merrick Garland would actually do that when he was confirmed. Those hopes have been shattered. You have been a loyal deputy, standing alongside that partisan corruption of Department of Justice. You have been willing to devote massive resources to targeting individuals that are perceived to be political opponents of the White House. And you have been willing to devote 0 resources to protecting individuals who are perceived to be political opponents of the White House. I want to ask you about a statute you've been asked about already, 18 U.S.C. 1507. You're familiar with this statute?
Yes.
It's a criminal statute that says whoever with the intent of influencing any judge pickets or parades in or near a building or residences occupied or used by such judge shall be fined or imprisoned under this title, or imprisoned not more than 1 year or both. Now, the entire country has seen hundreds of protesters outside the homes of Supreme Court justices night after night after night. You turn on your TV and you see violations of this criminal statute over and over and over again. How many prosecutions has DOJ brought under 18 U.S.C. Section 1507 under your leadership?
There have been no prosecutions under 1507. We're pursuing an attempted murder case against an individual who
0 is the
threatened
answer.
Justice Kavanaugh.
I'm quite aware, and you're responsible for that, allowing these protests night after night after night. The violent threat of homicide of the individual who traveled across the country attempting to murder a Supreme Court justice, that was fueled by DOJ refusing to enforce this statute. Now, it's not an accident that DOJ refused to enforce this statute. The U.S. Marshals gave a presentation. The General Counsel's Office of the U.S. Marshals, if you look at one of the pages from that presentation, the General Counsel's Office stated the goals of the Residential and Personal Protection Mission: keep SCOTUS justices and their family free from physical harm, do not interfere with lawful First Amendment protected activity, avoid, unless absolutely necessary, criminal enforcement actions involving the protester or protesters, particularly on public space, and making arrests and initiating prosecutions is not the goal of the Marshals' presence at SCOTUS residences. Are you familiar with this presentation?
I am. I'm familiar with the fact that the U.S. Marshal Service Director has been explicit, has been clear that the Attorney General has repeatedly directed him to enforce all federal laws, including 1507, and that his #1 priority, and that of his many deputies assigned to a 24/7 security presence, is to protect the life, the safety, the property of the justices and
Did you or
their
anyone
family.
from the DAG's office meet with the U.S. Marshal Service and discuss Section 1507?
I regularly meet with the director of the Marshals Service, the
And
Attorney
have you
General.
discussed 1507?
I discussed the Attorney General has been quite clear, and I have been quite clear with the director of the Marshals Service. The
Are
Attorney
you familiar with
General's-
this presentation?
I've seen those slides, if they're the ones that Senator Britt presented to the Attorney General. But I want to be quite clear.
This is the moment the entire exchange pivots on. A written document, not a rumor, not an allegation, is sitting on that desk. It says in underlined text that making arrests is not the goal. That is not ambiguity. That is policy. And what makes this exchange so dangerous for the Department of Justice is that no amount of verbal redirection changes what is written on that page. When an institution responsible for equal enforcement quietly carves out exceptions based on who the protesters agree with politically, the rule of law doesn't bend, it breaks. The question is whether anyone in that room has the authority to actually do something about it. Drop one word in the comments. Does a written instruction override a verbal directive? Yes or no?
About the direction given to the Marshals Service through the director of the Marshals Service. He has been clear that the Attorney General directed him repeatedly to enforce all federal laws, to
With
make
respect,
his
Ms.
number
Monaco,
one priority.
that is demonstrably false, because this is written instruction. Making arrests and initiating prosecution is not the goal. That's not an instruction to enforce the law. That is exactly the opposite. It is 180 degrees. It is instructing them. It is not the goal to arrest anybody, despite the fact that the criminal statute said they shall be imprisoned. You made a political decision, Merrick Garland made a political decision, that because you agree with the protesters, you don't like the decision the Supreme Court justices made, the marshals were instructed, don't arrest anyone and don't enforce federal law. Isn't that correct?
That is not correct, because the Attorney General and I and the Marshal Service Director are so concerned about potential threats to the justices. The Attorney General directed in an unprecedented step, 24/7.
Not what this says in writing.
24/7.
What does this say in writing?
I don't have the right glasses on for that, but Senator, the Attorney General was very clear with the Director of the Marshal Service, and the Marshal Service Director has said the same thing.
The word
that
not is even underlined.
The number one priority given to the Marshal Service for their unprecedented protection detail for the Supreme Court justices is to protect their life, their
But
safety,
to
and
ignore
their property.
1507.
To protect their life, their
To
safety.
ignore federal criminal law.
Respectfully disagree with that characterization.
That's what
sir.
the written instruction says. Not is underlined. Do not make arrests. Do not initiate prosecutions. Up is not down.
The Director of the Marshal Service has been very clear. The Attorney General directed him to enforce all federal laws, but that his number one priority is to ensure the safety
Ms. Monaco,
and the
what you're
protection.
saying is objectively false.
Time of the senators.
People can deflect. People can redirect. People can speak confidently about conversations that happened behind closed doors, about verbal directives that were supposedly issued, about a director who was allegedly told to enforce all federal laws. But a written slide, underlined, formatted, distributed inside a federal agency, cannot walk anything back once it is sitting on a Senate desk under hearing room lights. What just happened in that exchange is not a political talking point. It is a structural contradiction exposed in real time. On one side, a senior official claiming the Attorney General repeatedly directed full enforcement of federal law, including 18 U.S.C. 1507. On the other side, a physical document from the U.S. Marshal's own General Counsel's office stating in plain language that making arrests and initiating prosecutions is not the goal of their presence at Supreme Court justices' residences. Both of those things cannot be true at the same time. Here is what nobody is asking loudly enough. If the verbal directive to enforce all laws was as clear and repeated as the Deputy Attorney General claims, why does the written operational guidance say the exact opposite? Written policy is not a miscommunication. Written policy is what agencies actually run on. Verbal assurances given to a Senate committee do not change what a field agent reads before a shift. Think about what this means if you are a Supreme Court justice living under that protection detail. The people assigned to guard your home are operating under a written instruction that says their number one priority is your physical safety, and that arrests are not the goal. That sounds protective on the surface. But what it actually does is remove the one legal mechanism that deters people from showing up at your home in the first place. Remove the consequence, and you remove the deterrence. The attempted murder case referenced in this hearing did not emerge in a vacuum. It emerged in an environment where the message, sent through inaction, sent through zero prosecutions, sent through a written policy that deprioritized enforcement, was that this particular criminal statute would not be applied. Now consider the statute itself. 18 U.S.C. 1507 is not vague. It does not require interpretation. It says whoever pickets or parades near the residence of a judge with the intent to influence them shall be imprisoned. That word, shall, is not discretionary language. It is mandatory language. Prosecutorial discretion exists, but prosecutorial discretion applied uniformly across every case involving this statute for 2.5 years, producing zero prosecutions while nightly demonstrations were broadcast on national television. That is not discretion. That is a decision. Why now? That is the question. The timing of this hearing matters. This exchange is not happening because the law changed. The law has been the same the entire time. This is happening because the political cost of the silence finally exceeded the political cost of the confrontation. And what the Deputy Attorney General walked into was not a debate about policy, it was a document ambush. The senator did not ask for her opinion on enforcement philosophy. He showed her the written instruction and asked her to explain the gap between what the agency said in public and what it put in writing for internal use. Supporters of the DOJ's approach would argue that context matters. They would say that the primary mission at those residences was always physical protection, not criminal enforcement, and that conflating the two misrepresents the operational reality facing the marshals on the ground. They would argue that arresting protesters in a charged political environment carries its own risks, escalation, optics, civil liberties challenges, and that the Attorney General made a judgment call that prioritized safety over prosecution. Critics would counter that this is precisely the kind of selective non-enforcement that erodes institutional credibility, that if the same standard were applied in any other political direction, if protesters outside the homes of officials aligned with the current administration were met with the same written policy of deprioritized arrests, the outcry would have been immediate and bipartisan. The double standard, they argue, is not incidental. It is the point. What both camps are missing is the downstream effect on judicial independence itself. When sitting justices cannot rely on consistent legal protection, when the enforcement of statutes designed specifically to shield them from intimidation becomes contingent on the political climate of a given administration, the independence of the judiciary is no longer a structural guarantee. It becomes a variable. And a variable judiciary is not a co-equal branch of government. It is a pressure point. If this is the kind of analysis you are not finding anywhere else, you already know what to do. There is a historical parallel worth sitting with. In the years before the Civil Rights Act, selective non-enforcement of existing federal statutes was one of the primary tools used to signal to local actors which laws the federal government intended to back and which it would quietly allow to lapse. The mechanism is not new. What changes is who it is aimed at and what it is designed to protect or expose. The final line of this exchange lands harder than anything said before it, not because it is the loudest moment, but because it is the most precise. A senator looks at a deputy attorney general and says, "Up is not down." That is not rhetoric. That is a logical statement about a written document that cannot be reinterpreted by confidence alone. This story is not finished. A hearing ends. A document remains. And somewhere between the verbal directive that was supposedly given and the written policy that was actually distributed, there is a gap that no amount of committee testimony has closed. The next question is who fills it, and whether anyone will be watching when they do. If you made it this far, subscribe, share this with someone who needs to see it, and drop your take in the comments, because this conversation is just getting started.